Good evening, everyone. I'm Rakhi Gautam from greytHR, the moderator for the session today. We are delighted to have you join us for the sixth episode of the PSP Parichay Webinar series by greytHR. Thanks to everyone for taking out the time and joining us. Now, before we dive into the topic, let's do a little housekeeping on how the session goes. So, the session is divided into two parts. The first part will be the presentation by our expert, which will then be followed by an audience Q&A. So I can say audience Q&A is where time is all yours, dear attendees. You can start putting across your questions and we will be happy to take them up towards the end. Also, the session is currently being recorded. So if you happen to miss out on anything, do not worry at all. We have got you covered. We will share the recording with you once it is done. And also, this webinar recording will be available on our greytHR's official YouTube channel. So you can always go there and watch it later. Now, I think we have the quorum with us to start the session. The topic that is there today, which is impact of data protection laws on payroll service providers. Now, in an era where data privacy is paramount, understanding the implications of data protection laws, especially for payroll service providers, is crucial. So today, we have the pleasure of welcoming CS Aashish Negi, Senior Manager Corporate Law at VV Kale and Company. He will shed light on how payroll service providers can ensure compliance with data protection laws, safeguard personal information, and leverage computerized payroll processing applications for better efficiency and security. So we are we are very happy to have you here with us today, Aashish. Let me quickly take you all through his profile and then we can start the session. So as an accomplished company secretary and law graduate, Aashish brings over 6 years of rich experience in the legal and consulting industry, showcasing a proven track record in business setup, delivery, and management. His extensive experience spans various facets, including corporate and commercial law, FEMA compliances, company secretary matters, corporate governance, risk management, RBI compliance, ESG implementation, CSR compliance, and adapt end-to-end contract management. He's dedicated to ensuring comprehensive and effective solutions in this dynamic landscape of corporate regulations and governance. So I can say that we have gotten the perfect person with us today. Thank you so much for joining us, Aashish, and it's a pleasure to host you today.
Thank you, Rakhi, and greytHR.
Great. So I think we can move on to our presentation now. Can we quickly have the presentation on screen? Okay, so while we set up the presentation, yes, here it is. Now I would like to hand over the session to you, Aashish. You can take us through all the insights that you have to share with us today, and we'll take the questions at the end. Thank you so much. Over to you.
Thanks, Rakhi. I believe that everyone will be able to see my screen.
Yes, it is shared.
So good afternoon to all, and thanks to greytHR and Rakhi for organizing this seminar today. Today's topic is Digital Personal Data Protection Law and its impact on payroll service provider. Change the slide. So the particular of today's webinar is brief overview of the data protection laws in India. Then we'll move to the Digital Data Protection Act 2023. And then we'll move into the impact on payroll service provider. And then not the last, but the benefit of using of payroll service application. So next slide, please. So I'll start with the brief introduction about the law. You might have heard the phrase, data is the new law. Oil. This highlights the immense value of data as businesses are tapping into generate significant profit. Like oil, data in its raw form is unrefined and must be processed to become a valuable. In today's expensive digital economy, individuals are essentially represented by data. Unlike opinion, data is preferred for its reliability and predictability, enabling us to forecast outcome, gains insights for improved business performance, and deceive better strategies. However, mishandling data can lead to severe consequences despite its inherent power. Data require legal regulation, which bring us to the data protection and privacy laws. Recently, India enacted its much anticipated law on this subject. Historical background. To grasp the importance of Digital Personal Data Protection Act 2023, it is essential to explore the historical context of data protection in India. Before this legislation, the country did not have a dedicated law specifically for digital data protection. This lack of a comprehensive legal framework left individuals susceptible to data breaches and privacy violations. So the first act who is dealt with the data protection is the Information Technology Act, which address confidentiality, privacy, and security for information stored in the computer resources. In 2011, the first rule which will help for the protection of data is issued by the Government of India. The rule will be named as the Information Technology Reasonable Security Practice and Procedures and Sensitive Personal Data or Information Rule 2011. Data Protection Rule were enacted under the Information Technology Act to protect the sensitive personal data and information collected from individuals by body corporate. These rules constitute the existing general data protection framework in India. In 2016, WhatsApp user policy is challenged in Delhi High Court. In this case, the Delhi High Court held that WhatsApp policy allowing it to share user data with Facebook was challenged. The High Court upheld the policy but ordered the deletion of user data from those who had opted out of the services. Additionally, the court instructed WhatsApp not to share information collected before the updated user policy came into effect. This decision was challenged and is currently pending before the Supreme Court of India. In August 2017, the Supreme Court recognized right to privacy is a fundamental right. In the landmark decision of Justice K.S. Puttuswamy versus Union of India and others, the Supreme Court recognized that a fundamental right to privacy exists under the Constitution, enforceable against the law, even though it was not explicitly stated. This decision overruled previous Supreme Court ruling that held there was no fundamental right to privacy. Additionally, the court called for the creation of the data protection law to safeguard individual rights against private entities. The law in itself is effected in the year 2023. The object of the law is an act to provide for the processing of digital personal data in a manner that recognizes both the right of individual to protect their personal data and the need to process such personal data for lawful purpose and for matter connected therewith or incidental thereto. If we understand the object in a simple word, it means that the law in itself creates a balancing between the protection of individual right on the one hand and the necessity or processing of personal data and maintaining transparency on security of personal data of any person on the other hand. So it is a win-win situation for everyone who is using the personal data of any individual. Now we'll understand the applicability of the Act. The Act is applied only to digitize personal data. It means that any data which is not in the undigitized mode cannot come under the ambit of the data protection laws. So the law is applicable in a two different manner. The first one is within the territory of India. The second one is the outside the territory of India. In the territory of India, the data is processed in another two different points. First one is the personal data collected in digital form. For example, Aashish Negi has used various online services over time, including e-commerce website, digital OTT platforms, utility apps, ticket booking systems, investment application, and online banking services. Each of these interactions generate digital data points. Even if these data points are dispersed and managed by different organizations or applications, they collectively form a profile of Aashish based on the information provided across the various platforms. Under the DPDP Act, these individual digital data points enter across various platforms are considered personal data because they can be aggregated to create a pattern that uniquely identify Aashish. The other point of personal data is the data which we collected in non-digitized form and digitally subsequently. The perfect example of is that conducting a door-to-door survey where responses are recorded on a paper form and then these responses are entered into the computer system for analyzing through automated process such as statistical analysis or data visualization. Outside the Indian territory, the impact of the data protection law is any activity relating to offering of goods or services to data principle within the territory of India. The perfect example is Amazon, Alibaba, eBay, and eShop, which provide service to Indian consumers, and obtaining their primary details is required to comply with the DPDP Act. This is because they collect and process the primary detail of their user, thereby falling under the regulatory scope of the Act, which means that the Data Protection Act not only applicable to the data in a digital form, but also the data which is processed by the outside the Indian territory as well. The Digital Protection Act does not apply to the following category of things like personal data processed by individual for any personal or domestic purpose. The example of is that when we preparing any Excel sheet on a monthly budget for our family and use for the personal use and not for any third party entities. Personal use and not personal data that is made or caused to be made publicly available by the data principal to whom such personal data relates. Like when we are putting our detail on a LinkedIn, like email ID and mobile number, in the Instagram, Facebook, Naukri.com, they are the publicly available information. So which not comes under the ambit of Data Protection Act. Person who is under an obligation under any law for the time being in force in India to make such personal data publicly available. Like government organization uses our personal data to provide any subsidiary or any other benefit. So they are abide by the law to use our personal data. The Act gives equal merits for the protection of all digital person data and does not define any data category as sensitive personal data or critical data, which signify that all type of digital personal data, irrespective of the fact whether it is a person name, email address, or even their browsing history, are protected equally under the law. It does not create or demarcated any special category for certain type of data, such as calling some data as sensitive or some as a critical. Change the slide. Important definitions. There are several definitions in the Act, out of which I have listed the important definition. The first definition is the personal data. Personal data means any kind of data about an individual which can be used to identify that person or in relation to such data. The perfect example of is the PAN card and Aadhaar card through which any person can identify your name, your address, your date of birth, and your tax identity. The next definition is digital personal data means any personal data which is in the digitized form. The example of is the email ID, social media profile, online purchasing history, and digital photos. Next definition is data principal. Means the individual to whom the personal data relates. Data principal is the person like Aashish, Rakhi, or any other person whose information is provided to some other person for the processing. In case of children, their lawful guardian or their parent are considered to be the data principal, or if any person with a disability, their legal guardian would be considered as a data principal. So the next definition is data fiduciary. Data fiduciary means a person who alone or in conjunction with other person determine the purpose and means of processing of the personal data. So the object of the data fiduciary is he could be any organization or individual which is using your personal data for processing for any particular event. The next definition is data processor. Means any person who process personal data on behalf of data fiduciary. So uh, the perfect example of the data processor is the payroll service provider. So they act on behalf of any organization for the processing of the detail of their employee or third party vendors. Change the slide. So now we have to understand first the right and duties of the data principal. The data fiduciary or the data fiduciary is required to obtain the consent from the data principal, which should be free, specific, informed, unconditional, and unambiguous with a clear affirmative action and signify an agreement to the processing of personal data. Let's understand this with an example. Aashish, an individual, download VVK, a telematic app. VVK requests the consent of Aashish for the processing of his personal data for making available telemedicine services and assessing his mobile phone contact list, and Aashish signifies his consent to both. Since phone contact list is not necessary for making available telemedic services, his consent shall limited to the processing of his personal data for making available telemedic services only, not for any other purpose. Data principal shall have a right to withdraw the consent at any time. Let's understand this with an example. Aashish, an individual, is the user of an online shopping app or website operated by VVK, an e-commerce service provider. Aashish consent to the processing of his personal data by VVK for the processing of fulfilling his supply order and place an order for supply of a good while making payment for the same. If Aashish withdraw his consent, VVK may stop enabling Aashish to use the app or website for placing order, but may not stop the processing for the supply of goods already ordered and paid by the Aashish. Upon withdrawal of consent, the data fiduciary shall cease processing the personal data of the data principal unless such processing is required. If in case the data principal directed to the data fiduciary not to use their information further, they have to immediately stop to using their personal detail. Let's understand this with an example. X, a telecom service provider, enter into a contract with VVK, a data processor, for emailing telephone bill to the customer of X. Aashish, a customer of X who had earlier given his consent to X for the processing of her personal data, emailing of bills, download the mobile app of X and opt to receive bill only on the app of X. X shall itself cease and shall cause VVK to cease the processing of the personal data of Aashish for emailing bills. Now, when the data principal withdraw his consent, the data fiduciary is a duty bound to restrict itself not to process his personal detail further. Right and duties of the data principal. The first right of the data principal is to access information about his personal data. The data principal has the right to request from the data fiduciary a summary of the personal data being processed by the data fiduciary. For example, name, email, payment detail, etc. The data principal also has a power to identify of all other data fiduciary and data processors with whom the personal data has been shared, along with the description of personal data so shared. Let's understand this with an example. After discovering that the OTT platform shared your watching history with a data analytic company to personalize targeting advertising, you have full right to know the identity of such data analytical company and detail of your personal data shared with them. Any other information related to the personal data of the data principal and its processing as prescribed by law. Right to correction, completion, updation, and erasure of personal data. The data principal shall have a right to correct his inaccurate or misleading personal data, complete incomplete personal data, or update any change in the personal data accordingly with the help of data fiduciary. Right of redressal grievances. When the data fiduciary have power to process the information of data principal, the data fiduciary is a duty bound to provide data principal some grievances redressal. A data principal has a right to have easily accessible grievances redressable mechanism provided by a data fiduciary or consent manager in relation to the handling of data principal personal data or the exercising of his right under this act and its rules. The data fiduciary or consent manager must respond to the grievances within a prescribed period from the date of receipt. The data principal is duty bound to utilize this grievances redressal opportunity before approaching the board for the resolution. Right, the right to nominate any document, unique identifier, proof of identity or proof of address. A data principal has a right to nominate any other person or any individual who act on his behalf to question the data fiduciary or data processor in the event of his death or incapacity as prescribed. In this act, incapacity means the inability to exercise his right of the data principal due to unsoundness of mind or infirmity of the body. Data principal shall perform the following duty while exercising the right. The data principal is duty bound not to register any false or frivolous grievances or complaint. Furnish only information which is variable authentic. Like example, you cannot provide your address which is not in the documented. Like the address which is in the Aadhaar card should always provided or in the bank statement. You should always have the supporting document to confirm whether the data provided by you or information provided by you is a verifiable. Comply with the provision of all applicable law for the time being in force. Not to impersonate other person while providing his personal data for a specific purpose. In some cases, people use the detail of another person for accessing information. So the law completely prohibit not to impersonate any other person while providing his information. The data principal, if failed to meet the above stated obligation, it will have to pay the penalty of rupees 10,000. Consequently, the data principal are now obligated by law to provide accurate and verifiable personal information. Otherwise, they have to face the consequences which is provided by the law. Change the slide. Since the data fiduciary is an important person in the Data Protection Act, it have some obligation which need to be followed. So the first responsibility of the data fiduciary is to provide notice which contain about the personal data and which is to be collected. he has to provided why he is processing the data, what was the right of the data principal, and the way in which the right can be exercised. Let's understand this with an example. Ashish, an individual, open a bank account using the mobile app or website of VVK, a bank, to complete the know your customer requirement under the law for opening of bank account. Ashish specifically opt for processing of his personal data by VVK in a live video based customer identification process. VVK shall accompany or preside the request for the personal data with notice to Ashish, describing the personal data and the purpose of its processing. So the data fiduciary is a duty bound to specifically through a notice to provide what kind of personal data is using and what was the purpose of the processing of that data. See, the act is introduced in the year 2023. However, there may be a cases the data principal has provided consent before the commencement of this act. In this case, the notice has been sent by the data fiduciary immediately as soon as practicable to the data principal to provide what kind of personal data they are using and what was the purpose of the using of that data. The option to access the content of the notice should be in English or any language specified in the 8th schedule to the Constitution of India. So which means that the notice should be in the English language or any other language which is understandable to the data principal. Grounds of processing personal data. Data fiduciary for lawful purpose after obtaining consent of the data principal or for certain other legitimate uses can process the personal data of data principal. These legitimate cases include voluntarily provided personal data by data principal. Let's understand this with an example. Ashish, an individual, makes a purchase at VVK pharmacy. He voluntarily provide VVK his personal data and request VVK to acknowledge receipt of the payment made for the purchase by sending a message to his personal mobile. The VVK has a right to process the personal data of Ashish for the purpose of sending the receipt only, not for any other purpose. Data principal has not indicated does not consent to use personal data, which means that whenever a data principal is not provided a written consent, it does not means it has to provide a written consent not to use his personal data. If he or she has directed to the data fiduciary not to process further the data, he has to stop to process his data. Let's understand this with an example. Ashish, an individual, electronically message Sanjay, a real estate broker, requesting Sanjay to help identify a suitable rented accommodation for his and share his personal data for this purpose. Sanjay may process his personal data to identify and intimate to him the details of the accommodation available on rent. Subsequently, Ashish informs Sanjay that Ashish is no longer needs help from Sanjay. Sanjay shall cease to process the personal data of Ashish immediately. The other legitimate purpose to the use of data of the data principal by the data fiduciary is the state. The personal data of the data principal can be used by the state or any of its instrumentality for any function under any other law for the time being in force in India. For example, X, a pregnant woman, enroll herself on an app or website to avail of the government maternity benefit program. While consenting to provide her personal data for the purpose of availing such benefits, government may process the personal data of X, processing to determine her eligibility to receive any other prescribed benefit for the government. For matter concerning public interest, example, medical emergency, judicial uses, and for the purpose of employment or those related to safeguarding the employer from the loss or liability. So the data fiduciary is a duty bound to process the data of data principal for any legitimate use or any other purpose which is prescribed by the law. Please change the slide. So data fiduciary obligation not only include how can they use or process the data of the data principal, they have to provide data security to the data principal. A data fiduciary is duty bound to implement appropriate technical and have robust monitoring system to check whether the data processor is processing the data of data principal as per the instruction of the data fiduciary, and it should be used only for the purpose for which the data of the data principal is obtained. They should extend beyond technology to the people and process for defending their data against threats. Data retention. Data fiduciary shall, unless retention is necessary for compliance with any law, erase personal data immediately once the purpose of using that personal data is completed. Principal withdrawing his/her consent or as soon as it has reasonable to assure that specified purpose is no longer accessible for legal purpose being served, whichever is earlier, which means that whenever the data principal withdraw his consent or the purpose for which the data has been given completed, whichever is earlier, the data fiduciary is a duty bound to delete his data. Data process engagement. The data fiduciary may engage, appoint, use, or otherwise involve a data engagement processor to process personal data on its behalf for any activity relating to offering of goods or services to data principal only under a valid contract, which means that data fiduciary is a duty bound to enter into a contract with data processor. So in this case, the data processor is also under a duty bound to protect the personal data of the data principal. So in this way, the data fiduciary will be able to protect the data of the data principal. Change the slide. The Digital Protection Act has provided penalties and which is divided into two different categories: the major penalties and other penalties. Major penalty is the major penalty is deployed by the Data Protection Board. The Data Protection Board has a power to penalty up to 250 crores. Data fiduciary is also liable to pay a penalty of INR 250 crores for the breach in observing the obligation of data fiduciary to take reasonable security safeguard to prevent personal data breach. The data principal is also liable to pay penalty for INR 10,000 if they provided unauthenticated information. Other penalties: breach in observing the obligation to give the board or affected data principal notice of the principal data breach. The penalty is 200 crore in this case. If the data fiduciary, data principal, or data processor will breach any additional obligation of the significant data fiduciary, they have to make a penalty of INR 150 crore. If the data fiduciary is breaching in observation of additional obligation in relation to the children to protect their information in a manner provided in the law, or did not take any consent for their legal guardian, so they have to pay a penalty up to INR 200 crore. The law in itself provide if any of the party to whom the law is applicable breach any of the provision of this act or the rule made thereunder, they would be liable to pay a penalty of INR 50 crores. Please change the slide. What is the status of payroll service provider under the DPP Act? The payroll service providers shall be regarded as data processor under the Digital Personal Data Protection Act 2023. A data processor is an entity that processes personal data on behalf of a data fiduciary, which is the organization or individual determining the purpose and means of processing personal data. The responsibility of payroll service provider under the DPDP Act 2023 is the processing of the personal data to maintain security of that data, compliance with the instruction given by the data fiduciary, to maintain confidentiality of the data provided by the data fiduciary, to inform the data fiduciary about the breach of any data, to maintain the record what kind of data processed by them and what was the purpose of the processing, and assisting to the data fiduciary in the processing of the data. Let's understand this with an example. ABC Private Limited that outsource its payroll services to XYZ payroll service provider. In this case, the data fiduciary is a ABC Private Limited and data processor is XYZ payroll services. ABC Private Limited collect personal data from its employees such as name, address, bank details, and salary information. Then ABC Private Limited instruct XYZ payroll services to process this data to manage payroll, calculate salary, withhold taxes, and generate payslip. What type of personal data do payroll service provider access? During the course of rendering payroll services, the payroll service provider access various personal detail of the data principal, that is Aadhaar information, PAN information, banking detail, and personal detail. Identification. So the payroll service provider access the information in a three different category, like identification information, which will include the name of the data principal, the date of birth, his identification details, his employer identity number. Contact information, their home address, email address, phone address. Employment information, job title and role, department, employment, start date. Who is primarily responsible for the protection of personal data? Data fiduciary are responsible for their data processor. DPDP Act compliance include the implementation of reasonable security safeguards. When offering goods and services to individual, a data fiduciary may only engage a data processor under the valid contract. A data processor are still responsible to ensure that adequate measures at their end for the data protection are taken. Let's understand this with an example. Company ABCD Private Limited, data fiduciary, outsource its payroll processing to XYZ Payroll Services data processor. Company ABC Private Limited is primarily responsible for ensuring that its employee personal data is collected and processed in compliance with DPDP Act 2023. This includes ensuring data security, obtaining valid consent, and protecting the data against breach. XYZ payroll services must follow ABC Private Limited instruction on how to process the data, implement necessary security measure, and notify ABC Private Limited in case of a data breach. Although XYZ payroll services has obligation under the Act, company ABC Private Limited hold the primary responsibility for the protection of personal data. In summary, the data fiduciary is primarily responsible for the protection of personal data under the DPDP Act 2023, while data processor must also comply with specific obligation to assist the data fiduciary in fulfilling their responsibility. Please change the slide. Suggested action to be taken by the data processor. The data processor will carry out detailed client-wise analysis of personal data collected by them during the rendering of services, including manner in which such data is presently collected, assessed, stored, and protected. Develop and adopt practices for safe collection of data, such as use of drives or cloud technology, or require data fiduciary to save this data at their end only and provide access from their internal cloud systems. Once the data is collected, adequate measures need to be enforced for storage of the data, duly protected by password and access restriction. Contracts may be signed with the clients, that is data principal or data processor, to cover specifically the below aspect: personal data which the client would be sharing with the data processor, manner in which the data shall be shared. The client shall remain responsible to ensure that the data principal has provided valid legit consent in a manner provided in the DPDP Act. The client shall remain responsible to inform the data processor in case any data principal has withdrawn his consent and for deletion of stored data. Sign letter with employees of the data processor who process personal data of the employee of the client to be ensure privacy of the data and to face consequences in case of breach. Sign agreement with second level data processor to ensure data privacy. Change the next slide. Benefit of using payroll application. The payroll application automatically calculates salary, which will help to avoid any kind of manual errors. It will encourage employee to take to use all the services independently. It will help for the statutory filing easily. An ability to implement diverse structure requirements such as tax exempt reimbursement, etc. It will help to secure storage of the data, and it will also help operation such as preparation of payslip, accounting of joint ventures, investment declarations, letters, and generation of Form 16s. Since by taking these actions, data processor can ensure they comply with the DPDP Act 2013, safeguarding personal data and support data fiduciary in fulfilling their legal obligation. Since the Act is very comprehensive and we have discussed only the historical background, important definition and actions will be taken by the payroll service provider to protect data of the data principal. We will discuss other aspects of the law in the upcoming sessions. Thanks everyone for the patiently listening the session.
Sure. Thank you so much, Aashish. That was very comprehensive, I must say. A lot of definitions, but I think what really worked in our favor was that you gave those definitions in the starting, right? And then we talked about data processor, data principle. So it helped us understand with also the examples that you spoke of. So thank you so much for such a comprehensive presentation. I'm sure people have taken their notes, and as promised, this will also be sent to you on your email ID. So you can always watch the session later, come back to any points that you feel like you need more clarity on. And we will also be sharing Ashish's email ID with you if you want to connect with him directly, personally, for any queries you might be facing with understanding of this digital data protection laws that's been recently introduced in 2023. You can connect with him, and I'm sure he'll be happy to help you out. Okay, so that now we are done with the presentations. Let's quickly move on to the questions that we are getting from the audience. We have the first question from Radha. Um, as the provisions are not yet implemented, for what is the anticipated timeline for full implementation of the act?
So it will be Radha. Hello.
Yes, yes, you're
Yeah.
audible, Ashish.
So the law not yet notified. So the implementation will be provided by the legislature. We cannot
So are
confirm
we
the
looking
date.
at any timeline, or is it yet to be decided?
It is yet to be decided.
Okay, sure. But it's, good to understand this in case, one day you receive a notice that, okay, it's to be implemented from XYZ date. You'll have to have everything ready for that. Okay, moving on to the next question from Hiril. I missed the definition of data fiduciancy. Please explain again. If you could please explain the
Yeah,
definition.
yeah, yeah. So data fiduciary, if we understand with an example, it is any organization or individual who is processing the data of data principal. Data principal could be anyone. It should be you, me, or any organization whose data will be processed by the data fiduciary. So the data fiduciary is the organization which use your information and process those information for the specific purpose.
Okay, so in terms of this discussion that we're having, especially for payroll service providers, we can say that payroll service provider, because they process other data of other people, of data principals, they are data fiduciary. Is that correct? Are
Yes,
we?
ma'am.
Okay, correct. Thank you so much for that, Ashish, and I hope Hiral, that helps you understand the question. Now, moving on, there's one question from Aarti. How does greytHR help service payroll processes to ensure compliance of this law? This Aarti, we will be happy to connect you with our product team or the customer success team, who will be happy to give you a thorough demo on how this is done through greytHR application. And we would be happy to arrange for this. You can send me an email on any queries related to greytHR, and we will be happy to take that up. Okay. There's one question from Aarti again. This is, as I understand, only restriction of access of data on system is the only check that can be kept. Please guide if any other steps are required to be kept by payroll service providers.
So, Rakhi,
Aarti. Yeah.
uh, uh, Aarti, so Rakhi, you can share my
Sure.
email ID to her, and then
Okay. Sure, Aarti, we will be happy to connect you for this offline. This might require a deeper discussion. We will share Ashish's email ID with you, and you can connect with him separately. Thank you for your question and attending the session. Moving on to next question, which is from Amrapali. Does HR data, like employees' personal data, have any retention limits?
yes, sure, it has a retention limit until the employee is with you. You can retain his detail, and if it is not your purpose, you can delete. Or if he or she left the organization, you are duty bound to delete their data, their personal data.
Got it. Understood. Thank you so much for that, Ashish, and I hope that answers the question for you, Amrupali. Moving on to any more questions that we have. There's one question from Hiral. Any document as an employer to ask from the data fiduciary, so that we are sure that they are following DP Act. Please guide.
So Hiral, generally the employer in itself is a data fiduciary. So
Yes, that is what. Yeah.
you are in the part of, if you are an employee, you are the data principal. So you can ask any information, even you can ask from the data fiduciary to whom you have shared your information as well. See, in some cases, we will also share our employee information to third party. So you can ask from them to whom you have shared the information and what kind of information you have shared with them.
Sure. So we can easily ask them questions as to what the kind of information are you sending ahead, and they are, duty bound to, share the information with us. Okay, thank you so much for that, Ashish. I hope that answers the question for you, Hiral. There's one comment for you, feedback from Anil. Please convey my thanks to Ashish. So thank you so much, Ashish,
Thank
for
you, everyone. Thank you,
today.
Anil.
I don't see any more questions. We will just wait for another 2 minutes. If we get more questions, we can take those up. Okay,
Sure.
so there's another question from Dinesh. It's a
Hmm.
similar sort of question. Can we share the employee data to vendors for insurance or any other benefit services without the permission of employees? Or do we need to take a written acknowledgement before sharing?
See, it would be beneficial for you to take the written consent before sharing detail of your employee or any other person.
Okay. I hope that answers the question for you, Dinesh. As I also understood one thing, at least from this session, was that as personal, as individuals, also not just as representing an organization, as personal individuals, also we are very, we share our data just like anywhere. Somebody asks us to fill a form, and we just write our phone number there, and it's easily sent to them. And now it's up to them how they use or misuse the data as well. So as individuals also, I think it's very important that we are cautious of how we are sharing our data and who we are sharing our data with. So thank you for that, Ashish. Moving on to my next question, I think we have received one question. Okay, Dinesh says thank you, Ashish. I think that answers the question. Our next question is from Shravya Shetty. Is it required to take the consent every year from the employees?
No, it is not required. See,
Okay.
until he is revoke his power to use his personal detail, you can use it.
Okay. I hope that answers the question for you. Thank you so much for that question, and making the session more interactive. It's always good to have questions coming in from the audience. We can also see how you perceive the session. If there are any more questions or any feedback, also if you have, if you want to share that with us, you can do so. There are no more questions right now. We'll again wait for another 5 minutes since we have the time, and we'll take those questions. But in the meantime, can we have the final presentation on screen, please? Okay, as a lot of you already are aware, we have a Great Tribe community, which is a knowledge sharing platform by Great HR. So we have experts like Aashish Negi there, HR experts, CAs who can help you with any legal queries, any queries related to labor laws, to this act, or in fact anything related to HR in general, workplaces in general. If you have any questions, you can sign up to this community and have access to these experts there who will be happy to help you with the insights. And we have already over 9,000 plus HR experts here. So it's a free community. If you want to sign up, you're already not a part of it, you can do it today. Can we move to the next slide? And also we are available on Great HR. On Great HR is available on WhatsApp. You can see this QR code on your screen. If you want to connect with us on WhatsApp as well for any queries related to customer support, promotions or updates, or any new features that we are launching, you can just scan the QR code, and you can connect with us on WhatsApp. We will be happy to answer any questions that you might have there as well. Also, as I said in the beginning only, that this session is recorded, and the recording will be shared with all of you. It will also be available on Great HR's official YouTube channel, so you can always go there and watch it. And apart from this, if you have any more questions, any queries, feedback, or anything related to our upcoming sessions as well, you can write to me on rakhigotham@creative.com, and I will be happy to get back to you with the responses that you seek. So thank you so much once again for joining us, and thank you so much, Aashish, especially for joining us today and doing that very comprehensive session. It's very important to understand, how we are dealing with data today and how cautious we have to be while using it.
Thank you, audience, and thank you, Rakhi and Great HR, for giving me opportunity to speak on this topic.